when the question is, can the government do that? The answer is in constitutional law, right? There are all kinds of different kinds of law. When has somebody committed a crime is one area of law. When does somebody owe somebody else money, right? That's other areas of law. When the question is, can the government do that? The answer to that question is in constitutional law, which makes this a really interesting time for me, since that's what I teach. I would venture to guess that that for most of us, we've never seen such sweeping governmental regulations, right, that affect so many of our lives. And in all of my videos, you always have to be prepared for a canine interruption like this one. So, can the government do that? So there's a lot of questions. Can the government do what? Can the government shut down our schools, right? Tell me I can't send my kids to public schools. Can the government tell me I can't go to work, right? Can the government tell me I can't leave my house except for certain purposes, right? Can the government tell me that I can't visit sick relatives? If there is a vaccine, to COVID-19 at some point, or coronavirus, can the government make me, get vaccinated, or make me vaccinate my kids? So you got all these questions about what the government's allowed to do. Now, before getting into specifics, in the last video I said the same thing, you got to sort of cover some general territory before you get into specifics. Whether the government is allowed to do X, right, whatever it is, depends on what test a court would apply to the government's regulation or its action. These tests typically in constitutional law come in the form of what courts refer to as levels of scrutiny, right? There's certain levels of scrutiny, 3 that we're going to talk about today. And so whether the government can get away with doing something depends on, what level of scrutiny, what level of review, if you will, the court applies to the governmental action. Now, I'm going to talk about this today and using the word demystifying, because so much of the law, especially constitutional law, can be very dense. I remember when I was in law school thinking sometimes I was swimming in a sea of syllables, right? They just seem to be strung together in no particular order. A lot of them are in Latin, right? So it can be really difficult to wade through this, and it takes a while when you study this stuff to realize that although the courts are using fancy language, they're really just talking about pretty simple approaches to the law. So, big question, can the government do that? There are certain things that when the government does it, right, or is accused of doing it, would raise serious suspicions on the part of a federal judge or any court. Highly suspicious things that the government can do would be things like take away people's fundamental rights, whether those rights are listed in the Constitution, or whether the Supreme Court has said that they're fundamental rights, even though they're not listed, like the right to choose to whom you get married, right, things like that. If the government's taking away those rights, you're going to see a court, right, with the tackles up, right? That's highly suspicious. It's also highly suspicious when the government targets a group that the court or federal courts have said are suspect. There's the word, right? Suspicious, right? Suspect classes. Classes like ethnicity, right, where that's an immutable, unchangeable characteristic. There's a long history of targeting people based on their ethnicity, right? So it's highly suspicious, right, when the government does something, right, that targets a particular ethnic group, for example. So those are highly suspicious things that the government would do. The government could also do something that's somewhat suspicious, right? Instead of actually taking away somebody's fundamental right, just messing around with it a little bit, right? Moving it around, telling you how you can do it, when you can do it, right? Maybe the government's targeting a right that, although it's recognized as a constitutional right, is not quite as highly ranked as other constitutional rights, right? So you have, that would be a little bit suspicious, right? Somewhat suspicious. Also, third, you have most of what the government does is actually not highly suspicious or even somewhat suspicious. There is no discernible interference, right, with fundamental constitutional rights, and there's no indication from the facts, right, that the government is really targeting people based on, immutable characteristics and targeting people who have a history of being targeted for sport. So the analogy I use is, the way courts treat the government when the government's accused of doing something wrong is the way parents treat kids when kids are doing something, or allegedly doing something wrong. There are certain things that your kid can do that would raise, and I'm just using some examples here that I think most people would agree with, right? That would be highly suspicious, right? Your kid does something really suspicious, like causes an injury to a sibling, right, or skips multiple classes at school, right? Wouldn't that be the kind of thing that would raise suspicions, right? And let's talk about what kind of test you would apply to that, right, in resolving the case in a minute. But that's the kind of activity that would be like the government picking on somebody because of their ethnicity or taking away somebody's fundamental rights, right? Highly suspicious. Then there are other things that your kids can do that are somewhat suspicious, right? Gets in a tussle at school. I don't know about you, but I'm not a parent, but if I had a kid and they got into some kind of tussle at school, all right, I want to know why that happened, but I'm not as worried about it as if the kid was skipping out on classes or if the kid actually injured a sibling or something like that. They're kind of gradations, right, of seriousness. Kid gets home 15 minutes late, right? Well, that's not good, right? Again, I want to know a reason. I want to know a good reason. But it's not the kind of thing that raises right, my ire or my hackles the way Category 1 would. There are other things that kids can do, right, depending on their age, I suppose, that don't really raise a lot of suspicion at all, right? If a kid says, I want to take a nap, I'm not going to get all worked up about that, right? I might want to know why. Do you feel okay? Something like that. But I don't find it inherently suspicious. If a kid's a teenager and has certain privileges, car privileges, then if the kid asks for the keys to the car, there's nothing inherently suspicious about that. I still might be curious why. But I hope this makes some sense, right? So courts are like parents, right? Watching out for the people they're supposed to be watching out for. In the case of courts, in a constitutional case, they're watching the government, right? Is it doing something highly suspicious, somewhat suspicious, or not suspicious? And that dictates what level of review, what standard, what test applies. Okay, sticking with the kid part, right? Okay, what most of us do in those situations, again, even if we don't do it consciously, is apply a means-ends test, right? If a kid does something highly suspicious, like injure a sibling, right, cause a visible injury, let's say, to a sibling, right, that's going to cause us to ask basically two questions, right? Number one is, you're going to tell the kid, you better have a darn good reason, right, for why this happens. Now, I say darn good, I have a potty mouth, I'm trying to keep it clean for YouTube, but, I think many of us would use different, saltier language than that, but, right, if you've caused an injury to your sibling, boy, I want to know why, and there better be a darn good reason, right? Courts call that compelling, right? There better be a compelling reason why your sibling is visibly injured. The second thing you're probably going to look at is, okay, even assuming there was a good reason, was there any way to avoid it, right? Was there any way to achieve whatever you were trying to achieve without causing an injury to your sibling, right? You caused a bruise on your sibling's arm, right? Okay, so what's the reason? Why did you do that? Right, so I'm applying this higher, more kind of rigid test here, right? I want a compelling interest. Well, I was doing it to save his or her life. How's that for a reason, right? They had stepped in front of a moving vehicle, and the reason they have a bruise on their arm is because I yanked them violently, right, away from the danger zone. And then so the only remaining question is, was there any other way to do that? You're probably not going to second guess a kid in this circumstance and say, there was some other way you should have done that. What you're going to say is, well, okay, no, if your sibling had stepped in front of oncoming traffic, then violently removing them from the situation probably is the only way to get the job done, right? You don't have time to talk to them about it and reason your way through this problem, right? It called for serious, right, violent physical restraint, and it called for it immediately. So it might be possible to survive this level of review, but that's what we're looking for. Moderate suspicion. Okay, so you're 15 minutes late, right, getting home. Now we're not looking at the type of activity where I've got my hackles right all the way up, but now I want a good reason. It doesn't have to be a compelling reason. You don't have to tell me that you were saving somebody's life, right, to get away with being 15 minutes late. But I want a good reason. So this is the way parents reason, and courts do the same thing. And furthermore, being late has to be a good reason, right, or a good way, right, to have achieved whatever you were trying to achieve. So here, the kid might say, I was next door with the neighbor kid. We're both in the same class. We have a math test tomorrow. The neighbor kid was having a lot of trouble with long division, and I was just trying to explain it, and then that kid was trying to explain something to me so we could get past the test tomorrow. All right, that's an okay. That's not saving anybody's life. It's not a compelling interest, but maybe that's a good reason, an important thing to try to achieve, and maybe being late is justified, right? But it means, being 15 minutes late was an okay way to achieve it. You had to get this material, right, digested, and it took an extra 15 minutes. Okay. Then you've got your low suspicion activity, right? I want to borrow the car. Okay. Here I'm not applying any particular level of scrutiny. I'm probably curious, right? I want to be sure from my point of view that you have some kind of legitimate reason, but it doesn't have to be an important reason. If you have privileges to the car, right, it doesn't have to be an important reason or a compelling reason, but something, right? And so what? I need to go to 7-Eleven to get a pack of gum. Okay, well at least it's something, right? There's some reason why you need the car. And of course, let's say 7-Eleven is 3 miles away, then using the car would be a rational way to do that, right? It's not just that you have legitimate purpose, I want a pack of gum, but using the car, if we're talking about 3 to 5, 10 miles away, then okay, that's a rational way to do that instead of making you walk or run or whatever. So those are means ends tests, right? I'm looking at the means that you're applying or asking to apply, and I'm looking at the interest that you have right in mind, and I'm deciding whether whether the circumstances meet that test. Now, I hope this is coming through clear, right? Whether the circumstances meet that test, whether what happened meets one of these tests, depends on how high of a level, right, of a test you're applying. Am I asking for a compelling interest and means that are the only way to do it? Am I asking for an important interest and means that are an okay way to do it? Or am I saying any legitimate interest is fine as long as this is a rational way to do it? That is how you, and I'm speaking in broad generalities here, but that in most cases is how you decide whether the government's conduct is okay. So the fancy talk for all this, right? Because we can't just say, you have to have a really important reason, and this has to be the only way to do it. What courts say is, right, in circumstances where the government has done something highly suspicious, which again would be take away a fundamental right or target a suspect class. And I'm going to do another video about what those are, right? But this is the backdrop to that. If the government has done that, then the court applies what it calls strict scrutiny, where the burden of persuasion is on the government to show that it has that the means that it has chosen are what they call narrowly tailored, which means, right, the least restrictive and best way possible to achieving a compelling governmental interest. If what the government has done is somewhat suspicious, right, target a sort of suspect class or kind of mess around with people's sort of fundamental rights, then you get intermediate scrutiny, and under that level of review, the burden of persuasion is on the government to show that its means were substantially related to achieving an important interest. And then finally, you have rational basis review, where there's nothing inherently suspicious about what the government has done. In that case, the burden of persuasion switches over to the other party, the person challenging the government, right, who has to show either that the government has no legitimate purpose or that the means chosen by the government are irrational. And as my common law professor, and when I was in law school, put it, that means nuts, right? So under this level of review, you have to show there's no reason at all, or that the means related have nothing to do with achieving the interest. Let's say you ask a kid, why do you want the keys to the car, right? And the kid says, I need to get some rest. Well, that might be a legitimate thing, but borrowing the car and driving is not a rational way, right, to get rest, right, or to relax, right? There's no match there between the means and the end, so you'd probably say no under those circumstances, right? So it's possible to survive strict scrutiny, it's possible to survive intermediate scrutiny, and it's possible to fail rational basis review if you're the government, or in our family hypo, the kid. So, hope that makes some sense. Again, I'll be back talking about, because of all these questions, right, what are fundamental rights, what kinds of rights the court has said are not fundamental rights, what groups are suspect classes and what groups are not, and that will inform a whole lot, right, of how courts deal with the issues that are coming up now in the context of current events. So I'll see you for the next one.